So it looks like we got an update in the lawsuit. It looks like the lawsuit has been updated in regards to Drake and UMG and the motion to stay discovery. Inner City Press online had said, heading to Drake's versus UMG's case about Kendrick Lamar's diss track, Not Like Us, will Judge Vargas grant UMG's motion to stay discovery? Inner City Press on the case aims to live tweet thread below. And this is page 7 of the complaint that Drake had submitted. This is an image of one of the complaints that Drake had talked about previously. The lawyers are in place. 3 for Drake in front table, 3 for UMG at the back. All rise. Judge Vargas, I have a pending motion to stay discovery. Mr. Ransom, it's your motion. Ransom of Sidley for UMG. This is UMG's lawyer. There has been a change. Plaintiff has essentially withdrawn his first complaint, saying there'll be a second one, no discovery. Now remember, a motion to stay discovery is a formal request made to the court asking for a temporary suspension or a stay of the discovery process in a legal case. Discovery is a phase of litigation where parties exchange information, documents, and evidence relevant to the case. UMG in this case is requesting a stay because of the pending motion to dismiss. If a party has filed a motion to dismiss, in this case UMG, the case or certain claims, they might argue that the discovery should be stayed until the court rules on the motion. The reasoning is that if the case is dismissed, discovery may become unnecessary. But the judge right here on the second post says, Judge Vargas says, I don't really stay discovery. Why should I? UMG's lawyer says that Drake is amending speaks to the merits of our motion to dismiss. This song came out in May 2024. He didn't file until January 25. There is no urgency. This is UMG bringing up Drake trying to amend his lawsuit, trying to backpedal, fix things in his original complaint. And it took really long for him to sue. So the judge said, it's your burden. UMG's lawyer responded, they could have filed their amended complaint weeks ago. We would be burdened. They seek every document showing marketing for Kendrick Lamar. That's extraordinary. They seek compensation at Interscope. UMG's lawyer also continues, defamation cases are different. There is the First Amendment. Discovery should be stayed. The judge says, Mr. Gottlieb, Drake's lawyer, Gottlieb says, the test is if the defendant has shown the complaint is unmeritorious, facially without merit. Drake's lawyer says the motion to dismiss in this case is entirely an attack on the factual allegation in the complaint. UMG says no listener would believe the allegation in the song, so there are factual disputes, so discovery should not be stayed. This is Drake's lawyer still trying to get the paperwork. This is Drake's lawyer still trying to get the discovery, trying to get the contracts from Kendrick Lamar. Remember, those are the things that they had wanted, all the splits, all the contracts, everything in regards to Kendrick Lamar, PG Lang, everybody. They wanted to get all the contracts, Interscope, all that. Drake's lawyer also stated they had sent us a Rule 11 letter about only 5 paragraphs of our lengthy complaint about the use of streaming farms. We have exchanged letters. We intend to withdraw those, but it's the tiny portion of our complaint. Now, remember, a Rule 11 could be referred to as the Rule 11 of Federal Rules of Civil Procedure, which requires that an attorney ensure their filings are factually and legally sound. If a party believes an opponent's claims are frivolous, unsupported by evidence, or filed by improper purposes, like harassment, they may send a Rule 11 letter as a warning before filing a sanction. In this case, Drake's lawyer is saying that the opposing party, UMG, has challenged only 5 paragraphs of the entire complaint, specifically those related to the streaming farms. The lawyer is downplaying the significance of these paragraphs, stating that they are tiny portions of the lawsuit and that they intend to withdraw them, likely to avoid any potential sanctions or legal consequences under Rule 11. This suggests that while the broader lawsuit remains intact, there may be some weakness or lack of evidence regarding the streaming farm allegations. So it looks like Drake's legal team may not have strong enough evidence to support the streaming farms allegation, at least not enough to withstand a Rule 11 challenge. If they had solid proof, they would likely fight to keep those allegations in the lawsuit instead of withdrawing them. They might not have a direct or admissible evidence. They don't want to risk sanctions or losing credibility in court. 1, they might not have direct or admissible evidence. 2, they don't want to risk sanctions or losing credibility in court. 3, the streaming farm allegations were a smaller part of a broader lawsuit, so they're cutting losses to focus on stronger claims. Drake's team may not be able to prove it in court right now. However, the rest of the lawsuit is still moving forward. So even if Drake were to get the contract, even if Drake were to get the contracts and know what Kendrick Lamar is making, the deals that he has, PG Lang, all that, right? Interscope, all that, right? It's not going to matter at the end of the day because they're withdrawing their streaming farm complaint because they don't have enough evidence to prove that right now. This goes back to them amending the lawsuit and all of that, right? Drake's lawyer, their motion cites previous songs, so we intend to amend to address those. And the Super Bowl halftime show, it was more defamation. They continue to promote the song after they've been informed about the harm. My friend claims our requests are overbroad, but it's no different than any other corporate or institutional defendant. An NFL case had 40 defendants. Here, it's a single defendant. Requests generally limited to 1 year. Drake's lawyer states, we agree to this court standard protective order. Defamation cases have an actual malice standard, and we far more than met that. But there's no separate discovery rule in defamation cases. They are not a newspaper. They sell music. You say they are 16 RFP requests for production pending. Any third-party discovery? Drake's lawyer then says, we've served 3 third-party subpoenas, and we are trying to serve a 4th. They will go forward if discovery is not stayed. Drake's lawyer also states, we intend to depose a number of people. Judge says, you propose fact discovery closing in October? Drake's lawyer says, it's fast, but we are facing harm and want to move forward. The judge then says, in terms of the motion to dismiss schedule, you'll amend when? And Drake's lawyer says on April 16th. The judge then says, then they move to dismiss by when? And UMG's lawyer says, we'll have 3 weeks, then 14 for opposition, 7 days for reply. When she comes back from the break, Judge Vargas had stated, Drake is a top charting rap artist. He claims Not Like Us is intended to convey the message that plaintiff is a PDF file. There are more pleadings from April to May 28th. UMG argues discovery is premature and sought to adjourn. The judge says, discovery is not usually stayed, case cited, but I have considerable discretion to do it if I find good cause. An unmeritorious claim, burden, and unfair prejudice. UMG seeks to dismiss all 3 counts. I cannot assess the strength. The judge says, I cannot find on that basis that a stay of discovery is warranted. Here, there is only one defendant, which weighs against staying discovery. UMG can object to individual requests. The motion to stay discovery is denied. So the judge denied the motion to stay discovery. So obviously UMG wanted to delay discovery. They likely argued that the lawsuit should be resolved or parts of it dismissed before they had to turn over any documents or emails and any other type of evidence, right? But the judge is saying that they're going to deny it since there's only one defendant in the case. The judge found no strong reason to halt the discovery, so UMG must comply. While they can still object to specific requests, they can't avoid the discovery process entirely. So what this means for Drake, it means that his team can start digging through UMG's records, emails, contracts, internal communications, but UMG must respond to the discovery request instead of delaying the case. But remember, Drake's team backed off the streaming farm allegations, but discovery is still moving forward on the rest of the lawsuit. The discovery, if it will, could still reveal any other information about UMG. Contracts, emails, internal discussions, all that, right? But to be honest with you, I thought the whole purpose of Drake seeing the contracts was so that way he could see all the stream farming in the first place. I thought that's what Drake wanted to see. I thought he wanted to see, I know this is the defamation case, but a part of the case that he was trying to talk about was inflating the numbers, was making Not Like Us a bigger song than what it was. Everybody at this point was saying that that was the issue that Drake had, that UMG had made this a popular song. So if they backed off the streaming farm allegations, what's the point of having the discovery if you backed off from the streaming farm allegations? It just doesn't make sense. What other things are you going to look into when it comes to contracts and emails, any internal discussions between UMG, Kendrick Lamar? The judge then says, I'll set an argument on the motion to dismiss for June 30th at 2 p.m. 6 months for discovery seems aggressive. If 56 people were disclosed and might be deposed, so confer a file new proposal. So it looks like even though Drake is granted the discovery, it doesn't look like it's even going to matter at this point because his whole issue, remember, was about UMG inflating the numbers for Not Like Us allegedly and saying that this is the reason why it was a hit song and then claiming defamation right after because of what the song says. But them inflating the numbers was the biggest issue that Drake had because they were making the song bigger than what it was in his perspective, allegedly, right? But if you backpedal from those claims, if you backpedal and take them off the record, or if you try to remove that from your original argument, then what's the whole point of having the discovery once it's granted to you? You already talked about amending your lawsuit. And if you're focusing on other things in this case, I don't see what having contracts, emails, and personal conversations, I don't see how all of that is going to help you once you backtrack on the streaming allegations. The only thing that I could think of is that maybe Drake is starting to focus on the other issues at hand from the things that are said online. But y'all tell me how you feel about this right here and get back to me, man. Like I said, I really don't think him having the discovery at this point is going to make a difference once he went back and made changes and dismissed previous arguments. But y'all tell me how you feel about this and let me know, man. Like, comment, subscribe, and I'll see you on the next video, man. Peace. Keep it alleged.